now we are joined by Matt Ford of the New Republic, here to talk about a very busy week in the Supreme Court world. Matt, thanks so much for coming on.
Thanks so much for having me.
So let's start with Moore v. Harper, the independent state legislature case. I have read different analyses of this decision, ranging from pessimistic to optimistic. It seems that the pessimism is centered around the fact that the decision essentially empowers federal courts as opposed to doing something more broadly to protect election integrity. What's your take on how this decision was framed?
Well, it really depends on whether you're a pessimist or an optimist. If you're an optimist, you read the decision and you see that the court rejected quite decisively the independent state legislature doctrine, which is something that is a fringe theory on when state courts can review election laws for federal elections passed by state legislatures. If you're an optimist, you see that they've rejected that theory and removed a potential threat to the stability of the 2024 elections. If you're a pessimist, though, you see the little trailer that Chief Justice Roberts snuck in at the end there, where he suggested that, even as we're saying that state courts can decide these cases, we're also carving out a role for ourselves. Now, if you're a pessimist, you might be more inclined to think that that could lead to certain other forms of mischief down the road.
Right. And we've kind of seen some mischief, though, from the Supreme Court on elections, like now to turn towards pessimism. Bush v. Gore, an example of the Supreme Court overruling state courts for the worse. What's your take on that, fear of something like that happening, giving them essentially the last word when it comes to cases involving elections?
Well, I think it's somewhat inevitable. The Supreme Court was never really going to sit on the sidelines if there's another Bush v. Gore type dispute that the lower courts struggle to resolve. I think that the problem is not just is not whether they have this power necessarily, but how they use it. The problem that really stood out with what Chief Justice Roberts wrote was that he didn't seem to articulate any sort of standard, any sort of test, anything for lower courts to use to sort of guide how to do this. That hazy understanding is going to be ripe for future applications that may not be predictable. And of course, if you can't predict what the law is doing, it gives the impression that it's arbitrary.
Yeah, but then now I'm moving towards optimism again. Like the idea that the Supreme Court would satisfy leftist concerns over election integrity with a standard that we could all get behind, that seems like that was a bit of an unrealistic expectation. I mean, I think we've avoided the worst case scenario, which is allowing these state legislatures, which can contain crazy right-wing nut jobs, as we know, to have as much power over how elections are structured. I mean, this could, if they had endorsed this theory, as three of the justices seem to think would have been on the table for them, that would have opened up so many horrible outcomes potentially for election integrity in this country.
Absolutely right. And I think it's worth noting that this is a case that was involving partisan gerrymandering.
Yeah.
Now, that's something that Roberts has previously said the federal courts can't get involved in. He said that in a case in 2019. So now, if he had gone the other way on this, if the conservative justices had gone the other way on this, you would have a scenario where states could redraw these partisan maps that are highly favorable towards one party or the other, and in practice, it's usually the Republicans. And now federal courts couldn't review them, state courts couldn't review them, state constitutions wouldn't be able to affect them. In terms of dodged bullets, this was a huge one for the future of American democracy.
Well, happy to have some good news, because I'm not sure we will in the upcoming cases. But before we get to that, I also wanted to highlight, you've been writing about the Supreme Court and its approach towards tribal sovereignty. And oddly, Neil Gorsuch has a much more positive and productive interpretation of Native American case law and tribal sovereignty in this country versus, say, what Clarence Thomas has has delineated about what his approach is going to be in cases moving forward. But I guess let's just touch on that Navajo Nation case, the fallout from it, and where the fault lines or battle lines are being drawn, I should say, with respect to the conservative justices on tribal sovereignty.
Well, sure. I think that the Navajo Nation case really clarified a sort of enduring question that was circling the court over the last years, and that was, why is Gorsuch so passionate about these tribal law cases? He often sides with tribal sovereignty, but it's more than just that, right? He writes about it with great empathy. He writes about it very persistently, and it's something that clearly animates him. And I think what we've seen with the Navajo Nation case is that he's not just espousing this on his own. He's responding to something that he's seeing within the court, and that is sort of a move by some of the justices to disregard tribal sovereignty. And I think we see that in Justice Thomas's concurring opinion, where he sort of lays out how he thinks much of the Supreme Court's precedence on Native Americans should be overturned. That would have far-reaching implications for the tribes, and I think that Gorsuch's passionate defense of tribal sovereignty makes a little more sense in that context.
Yeah, and then in contrast with Thomas, Gorsuch being an outlier in this instance in a 6-3 conservative Supreme Court doesn't really help a ton of matters, because there's going to be a swing vote as well. But Clarence Thomas, as always, in the depths of being like the worst person of all time, clearly has a very different approach than what we've seen from Gorsuch.
Well, and I think that it really shows something about what originalism. We talk about originalism a lot. We talk about the court. We talk about how they read the Constitution. We're really seeing two different approaches to it here, and I think they're quite telling about themselves. Because when you read, Justice Gorsuch go through the history of Native American treatment in this country, the history of how tribes were moved and relocated, you see somebody who actually does appear to understand the original public meaning of what these provisions meant, how they fit into history. You contrast that with Justice Thomas, which very much starts from sort of a very narrow, constrained reading of the Constitution, and then just flows from there. It's a really striking difference in methodology that could have ramifications, obviously, for tribal sovereignty, but also speaks volumes about how they approach other cases.
Yeah, and what are some of the other cases that you feel? I know that they decided that they weren't going to overturn the Indian Child Welfare Act, but there could be more coming down the pipeline here. What's your sense of how this fight will play out in the coming years?
Well, the big question is what the other justices will do. We know what Gorsuch will do. We know what Thomas will do. Where do the rest of the court's conservative justices fall? And we've seen some signs that, there may be some wiggle room. Certainly with the Indian Child Welfare Act case, we saw Justice Barrett and Justice Kavanaugh join with Gorsuch on that one. And then, a week later, we saw them go the other direction in Navajo Nation. Whether or not those justices side with Gorsuch or Thomas in the long run will really decide the future of tribal sovereignty in this country for at least the next few decades.
Well, that's a scary proposition. Let's now talk about some of those upcoming cases, though, where the outcomes may not be as positive as they were in Moore v. Harper. We have the affirmative action case coming up, student debt, same-sex marriage in regards to that graphic designer person. But let's start with affirmative action here. These are two plaintiffs, right? Or two challenges to one, a private university, Harvard, and then UNC Chapel Hill, which is obviously a public one. But what the justices seem to be deciding between is overturning the precedent, which is Grutter in this case, if I'm not mistaken. It seems like they, based on oral arguments, are leaning towards doing so and essentially saying, hey, affirmative action's based on race for higher education. It's outlived its usefulness. We've solved racism in schools, and there you go. Is that your sense of how things are going to play out as well?
Well, the challenge with covering the Supreme Court is that it's always difficult to predict how opinions will actually come out. We've seen that in the last couple of weeks, certainly in the Voting Rights Act case last week. So I would never guarantee that something will happen. But I will say that it would be a tremendous surprise if the court does not overturn Grutter, or at least does not sort of severely limit affirmative action in college admissions. This is a slate of justices who has strongly expressed views against that in the past. We have Justice Thomas, who has argued that it was unconstitutional all along, all the way since 1868. And we have, Justice Roberts, who has argued that, he's got that famous line, the only way to stop discriminating on the basis of race is to stop discriminating on the basis of race. These are justices who very strongly believe that the Constitution is colorblind in all aspects and that you cannot use race as any factor in policy decisions. And I think that what we should expect, barring some sort of very surprising behind-the-scenes development, is that that's how the opinion will play out. It's really just a question of how far they will go in terms of, limiting it to just college admissions, or whether they'll speak more broadly about other aspects of diversity programming in society.
Yeah, is there no differentiator between public and private schools in this instance? Do you sense that there will be a way in which they try to parse anything on those lines?
I mean, it's always possible. The challenge is that, if for those who would make that argument that, Harvard, while a private institution, does receive federal funds. And so part of a condition of receiving federal funds is abiding by, the constitutional restrictions on race discrimination.
Right.
So that would be harder for them it would be very hard to thread that needle if that's the route they wanted to go.
There you go. Thank you for clarifying that. I remember that was part of why these cases were able to kind of be brought together now. On student debt here, people are also pessimistic based on oral arguments. As you say, though, it's very hard to predict. They seem to be skeptical about the authority that Biden had in this instance, which I think is silly. But the part that should be the easiest to undercut is the lack of standing by the plaintiffs in these student debt cases. Like, what is the harm that's being alleged here? But it seems, based on them taking it up, that they feel that that standing is sufficient for them to make a decision in this instance.
Well, they could change their mind on that, though. We saw that in the Indian Child Welfare Act case, which we just discussed. Right. Where they took up the case and then decided that some of the plaintiffs, in fact, did not have standing. And, whether you want to read that as them looking at it more closely and thinking, we were wrong, or whether you want to read that as them thinking, we don't want to get into this right now. We'll just say no standing and move on. I think the challenge with the student debt one is that you have a very clear contrast between justices who are very strongly against it on policy grounds per se. You had Robertson and Gorsuch saying that, what about the people who didn't pay student loans, which is sort of more of a political argument than a legal one. But, for the justices, standing is tricky. If you change the standings, the precedents for standing, you basically create more work for yourself, which is sort of a blunt way to put it. But, the justices are reluctant to tinker too much with arguing who can bring cases before the court. And, there are also questions about whether or not the Missouri state institution is supposedly being harmed by this is actually have legal standing to bring the case of its own, whether Missouri can speak on its behalf. This one's a lot harder to predict. I wouldn't be willing to guarantee that it goes any way or the other. And I think it comes down to really what the justices think about the procedural aspect and whether or not they think there might be another way to deal with this in the future.
And this graphic designer who is trying to challenge based on, I believe, what it was, religious objections that she didn't want to hypothetically make a website for a gay couple that could be getting married. This is, to me, it seems redundant with the cake case from a few years ago. But what is this case? How is it different? If you don't mind explaining that.
Well, with the cake case, we had a Colorado baker who declined a same-sex couple's request to bake a cake. There was a very clear fact pattern as to what went wrong. There was an injury. There was standing. This case is, like you said, a lot more hypothetical. You have a Christian web designer who thinks that Colorado will punish her if she refuses to design websites for same-sex couples. She does not currently design those websites. She has never designed those websites. And she only has her promise that she might do it in the future. That is pretty hypothetical, and that is pretty fraught ground to essentially ask for what could be a major change in First Amendment law before the court. But, this is a case involving religious freedom, and we know statistically that scholars have studied this, that the Roberts Court is more likely to rule in favor of plaintiffs who bring religious liberty claims than any court in the last 100 years. So whenever that happens, we have to wonder, is this a case where, the Supreme Court will actually look at it and say, well, procedurally, this might not be up to snuff. Maybe we shouldn't go this far on this front. Or maybe they'll look at it and say, you know what, this is an issue of grave importance to Americans' religious consciousness, and we should go full steam ahead.
Yeah. Clearly, there seems to be some understanding from the right-wing groups that are backing these efforts that they feel they'll have a more sympathetic ear, all the way back to Dobbs, which I think yesterday was the 1-year anniversary of the overturning of Roe v. Wade. And we now do have a preview of some of the things that after this term ends in a few days, what the Supreme Court is going to be starting to take up next year. You wrote about this in the New Republic. The fact that they have decided that they're going to take up a case that could prevent Congress from passing a wealth tax. What is this case? Who are the plaintiffs? How is this even possible? They're preempting a potential wealth tax?
Well, that's if you believe the plaintiffs, that's what they think the court can do in this case. This is a case that in the meat and potatoes is actually about the Trump tax cuts that were passed a few years ago. There was a provision in there that was being challenged. It involved a one-time repatriation tax. It's mind-numbing for anyone who's not a tax lawyer. But that's the basic gist of it, is whether or not Congress can levy that tax under the Constitution, under the 16th Amendment, or whether they have to do it under a different mechanism that's more complicated. Now, that dispute in of itself is interesting, but not really significant. What sets this one apart is that the plaintiffs and their lawyers explicitly push this case as a way to say, hey, the reasoning that you could use to strike this down could also be used against federal wealth taxes in the future. And we know that when Democrats, especially Elizabeth Warren, especially Ron Wyden, have pushed for these in recent years, there's been a lot of pushback from the conservative legal movement saying that they aren't constitutional. And so this is a way to sort of preempt that and get it before the justices before Democrats even have a chance to pass it. That's not my supposition. That's what the plaintiffs and their lawyers have actually said.
They are scared. It's funny to see in a way, but it's like, this could not be more clearly within the jurisdiction as laid out by the Constitution of what Congress is supposed to be engaged in. The power of the purse, right? Like, this is exactly what Congress's role is in terms of the congressional or the constitutional delineation of their duties, is it not?
Well, the plaintiffs argue, to their fairness, that the 16th Amendment only allows income taxes to be levied without apportioning it among the states. You have to basically adjust it by population for each state. But if you do the income tax, you can just levy an income tax on everyone. Now, the proponents of the wealth tax say, look, this is basically an income tax because, with wealth, you can borrow against it, you can take out lines of credit based on it, you can derive income from it even if it's not direct. They say, no, hold on. We want this to be read narrowly. We want income tax to be read narrowly so that you can't do this because otherwise it would violate the Constitution. And so how the justices come down on that could be decisive in whether or not Congress can do this without jumping through a lot of very difficult hoops in the future.
Honestly, there needs to be some sort of leftist or liberal mechanism that can do this kind of thing. Like say, God forbid, there's a Republican Congress and a president agrees that, hey, let's start to privatize Social Security and Medicare. I would love for a leftist group to bring a case based on similar grounds just because, like, hey, I don't agree with this, and the Supreme Court should strike it down, because that's essentially what they're doing. They're circumventing democratic process that hasn't even happened yet and trying to put a chilling effect on it via unelected priests, the Supreme Court.
I mean, I think that the Supreme Court, this case won't be heard until the fall. It won't be decided until probably next summer. The Supreme Court has gone through a lot in the last couple of years. It's gone through a severe decline, a very measurable decline in its public esteem. And I think that may weigh on the justices. Now, whether that will weigh enough on them to say, hey, this isn't as big of a case as it needs to be, that'll be down the road. But I think the more that people perceive the Supreme Court to be acting in ways that are inimical to democracy, that are partisan, that are political, the more likely it is that there will be a backlash. And I think the justices, if they want to retain the prestige and power that the institution enjoys, they have to be conscious of that, because if not, Congress will take action.
It really is incredible how, like, this Elizabeth Warren has a special place in, like, triggering certain legal conservative minds, whether it's the CFPB. They've been trying to attack that for years at this point, and they're successful in ways of bleeding it dry. Whether it be the wealth tax, just the threat of what she's been proposing, it's amazing to me. Yeah, there's a reason. I mean, you hear about how she's so despised on Wall Street for that kind of stuff.
If memory serves, and this is going a bit off of memory, I think there is even another CFPB case coming up next term. So, in a way, to make a bad pun, it really is the return of the Warren Court.
Well said. Well said. I mean, we can only go down from there, Matt. So I'll let you go because that was a perfect way to end it. Matt Ford of the New Republic. You can read his coverage, all his work about a variety of things, about covering the Supreme Court as well. Thank you so much for your time today. Really appreciate it.
Thanks so much for having me. It was a joy.
Appreciate it.